Welcome to Washington Legal Foundation's briefing. My name is Glenn Lammi. I am the Executive Director and Vice President of Legal Studies here at the Foundation. For those of you not familiar with the Foundation, we are in our 49th year of free enterprise legal advocacy and education on a very wide range of issues. We are very active at the Supreme Court, which I'll mention in a second. And we do 3 of these types of programs a year, one at the midterm point in February, one to wrap up the term at the end of June, beginning of July, and then one to preview the upcoming term in September. I want to thank you for joining us today. We've got a lot of ground to cover in just an hour, including at least one opinion, several oral arguments from the first half of the term, and a bunch of interesting cases set to be argued in the next 3 months. There are 7 pending cases, actually, in which WLF has either filed its own amicus brief or will do so, including 2 where we filed in support of successful petitions, the Monsanto versus Darnell case and the Cisco versus Doe case. I will start off by introducing our 2 panelists. Yaira Dubin is a partner with Sullivan and Cromwell, where she serves as co-head of the Supreme Court in appellate practice. She joined the firm from the Office of the Solicitor General in the Department of Justice. She served as a law clerk to Justice Elena Kagan at the Supreme Court, Chief Judge Sri Srinivasanan of the U.S. Court of Appeals for the D.C. Circuit, and Chief Judge James Boasberg of the U.S. District Court for the District of Columbia, which I would imagine right now would be quite an amazing thing to be doing. And I imagine Yaira is a little bit jealous she's not there right now. She's also co-taught the Supreme Court Clinic at Stanford Law School and a Supreme Court seminar at NYU School of Law. Corbin Barthold is TechFreedom's Internet Policy Counsel and Director of Appellate Litigation. He clerked for Stephen Merriday on the Middle District of Florida and Robert Cleveland on the Eastern District of Michigan. After his clerkship, he became an associate and later a partner in Los Angeles office of Brown George Ross, where he engaged in high-stakes complex litigation. He also served for several years as a senior litigation counsel, at WLF. I want to remind you that we are recording this webinar. If you have any questions, please use the Q&A function in the Zoom webinar toolbar. I think we will get started with a question for Yaira. So the court's issued 11 opinions so far. One that could have a significant impact on plaintiffs and defendants is Burke versus Choi. So could you talk a little bit, Yaira, about what the decision was there and how it might impact civil litigation in federal court?
Sure, and thank you so much for having me here today. It's nice to be with WLF. You certainly have a very active docket in the court this year. So we don't have too many blockbusters yet from the court, which is not totally unexpected at this point in the term. I think there's been a number of people who have been tuning in, waiting for certain more high level, let's call them A1 cases, but we haven't seen them yet. But one of the more interesting ones that has issued already, written by Justice Barrett, is Burke versus Choi. And the facts of this case are quite sad, but essentially it's a medical malpractice claim. And someone came to the emergency room and his ankle was hurt. And instead of taking care of the ankle in a proper way, he alleges that the emergency room staff made the injuries much, much worse and failed to provide appropriate follow-up care. The plaintiff is bringing a suit in federal court under state law, so under Delaware law, and it's a diversity case. And Delaware law says that a plaintiff can't sue for medical malpractice unless a medical professional, like a doctor, attests to the suit's merit in an affidavit that accompanies the complaint. And the question is whether that Delaware law requirement also governed this suit, even though this suit is in federal court. And the court said no to that. And the court said that the reason is obvious. It was a very short opinion, essentially. I think it was 11 pages. And the court says the way we think about the sort of procedural rules that govern in a federal case is you look at the Rules of Decision Acts, which tell federal courts to apply state substantive law and diversity actions, unless there's a federal law on point, and that includes the federal rules of civil procedure. And there's a federal rule of civil procedure, Rule 8, that says you do not have to include anything with your complaint other than a short, plain statement of your case. And the court said, okay, Rule 8 is directly on point. Rule 8 tells you exactly what is supposed to happen in this case. So it controls unless there's something invalid about the federal rule. And the way that the court looked at invalidity was to say the way you might think that Rule 8 is invalid is if Rule 8 is in fact substantive rather than procedural. Because to be a valid rule of civil procedure, it has to be procedural. And the court said that here there's no question in essentially a paragraph that Rule 8 is procedural and that resolves the case, and you ignore Delaware law, rejecting the argument that you would in any way look at whether Delaware law on this subject is substantive or procedural. That's not the inquiry. The only thing that matters is whether the federal law is procedural. So it's an interesting issue for this particular nuanced area of medical malpractice law. But if you don't practice in that area, I think the more important takeaway from it is one, that the court is going to, the action in these types of cases is really going to be whether there is a federal rule that answers the disputed question, right? And like Rule 8 doesn't specifically talk about affidavits, right? It doesn't directly and specifically address the thing that's at issue in Delaware law. Instead, what's happening is the court is saying there's a federal rule in this context, and whatever it says goes, and it doesn't matter if it specifically addresses this more nuanced approach in state law. And I think there will be a lot of action on things like that, which is, can you find a federal rule of civil procedure that you say governs the circumstances and therefore displaces state law? The second piece of the inquiry, right, whether that federal rule is valid, Justice Barrett is pretty clear that essentially every time the court has looked at whether a federal rule of procedure is valid, the court has held that it is in fact valid. It's very hard to satisfy the exception for an invalid federal rule. And, she talks about, we've upheld rules governing the certification of class actions, service of process, compelled physical and mental examination, sanctions for frivolous appeals. So I think, of course, litigants should preserve all of their arguments, but I definitely think the action is more on, is there a federal rule on point, rather than on, is the federal rule valid or invalid?
There's been some interesting discussion online about how the decision is going to affect libel cases and situations like slap suits under state law. There's a blog post on WLF Legal Pulse blog that gets into that part of it. So if anybody has an interest in reading that, that's there. So the court's heard oral arguments in 34 cases so far before it took its 3-week break. Most anticipated, obviously, is Learning Resources versus Trump. But there's 2 other decisions that could have far-reaching implications for the separation of powers: Trump versus Slaughter, Trump versus Cook. Corbin, did the arguments in those cases indicate where the justices are leaning?
Thank you, Glenn, and thank you for having me. The short answer is yes. Starting with Slaughter, I'm not going to give a lot of background here. This is the removal power case. All legal buffs are probably familiar with the basics here. Article 2 of the Constitution vests the executive power in the president and says that he shall take care that the laws be faithfully executed. The Constitutional Convention didn't really get around to defining whether the removal power is something that is in the sole discretion of the president. But then we've been arguing over it ever since, starting with the decision of 1789. This case involves the Federal Trade Commission and the removal of Commissioners Rebecca Slaughter and Alvaro Bedoya, although Bedoya has dropped out of the case at this point. The FTC Act says that FTC commissioners may only be removed for, inefficiency, malfeasance, and neglect, something like that, for cause, in other words. The FTC being a quintessential multi-member independent agency, of which we have many at this point. I think it's fair to say from the argument that we are going to see some kind of strengthening of the removal power, some kind of diminishment of the independence of independent agencies. And then the question is, how far does it go? The conservatives on the court seem unshaken in their historical understanding that as a matter of originalism, the president should have a full removal power. Amit Agarwal, able counsel for Slaughter, tried to argue that historical analogs like the sinking fund, in fact, muddy that history, saying, well, the president may have had overall control of an agency, but there were members of the agency that he had no power to remove. the sinking fund. The Chief Justice of the United States, for instance, was a member, so there was no way the president could remove that person. The justices on the conservative side seemed unmoved by that. So they seem intent on doing something. The question is, well, the way I would put it is there is something of an intra-conservative debate. Do you do originalism, come what may, though the heavens fall, or do you engage in a more sort of Burkean, small c conservative caution? Justice Jackson was, I think, the only justice who stuck up for the sort of Woodrow Wilson, neutral experts, there's real value here view of things. The real debate was between, do you mess up the system a lot to get it back to the way it was supposed to function? Or do you try and keep things, accept the accumulated wisdom of the past, the justices who set up the independents, the Congress who set up the offices, and try not to disrupt things too much? The way to do that would be to maybe keep Humphrey's executor and say, the independent agencies that we have, we're going to keep, but it goes no further. You can't create new independent agencies like this. Or you could even go a bit farther and say, well, Humphrey's executor stays, but it's only a limited amount of power that you can put in agencies, such that maybe the FTC as it existed at the time of Humphrey's, 1935, is okay, but almost no agency that exists today is okay. At the end of the day, though, I do think we're going to get a big ruling. Mr. Agarwal tried to give that Burkean, don't disrupt too much answer, but justices on all sides seemed unsatisfied with that. They want a result that isn't just sort of a Burkean mess. We're not going to tear down the fence because it has served us well. They want something that's logical and that logically fits. And so we ended up with a contest of slippery slopes, basically. On the one end, you had, say, Justice Kagan saying, well, if we accept that all executive power must be vested in the president, what happens to Article 1 judges? What happens to inferior officers? What happens to employees, federal employees? Can the president just wipe out the entire federal government and replace it with the people that he wants? And we go back to a spoil system. And then on the other side, we had justices like Justice Alito and Justice Thomas saying, well, Mr. Agarwal, could we create an independent agency, Justice Department? Could we create an independent agency, Agriculture Department? And Mr. Agarwal tried to fall back on the position that, well, no, departments that have exclusive executive power remain safe from removal limits. But he really struggled to give a coherent line there. He was trying to invoke some of the language in Trump versus United States, but he wasn't really able to flesh out details in a way that satisfied those justices. So a key moment occurred when Justice Kagan said, well, Congress thought these removal restrictions were okay, and it handed a lot of rulemaking power to these agencies. So if we make it so the president has full removal power, haven't we put a huge amount of power in the executive branch? And Justice Gorsuch immediately followed up with, don't threaten me with a good time. He said, well, wouldn't the solution to that be to restore the full Article 2 removal power and then start using the non-delegation doctrine to chip away at the rulemaking power of the agencies, which showed a real appetite to go the whole hog here. So if I had to predict, I'd say we're going to get a full strike down of Humphrey's executor. Turning to Cook, at least in Slaughter, it's pretty clear what the decision tree is, what the options are. The Cook case is a total mess. The Federal Reserve creates problems for the unitary executive theory because the unitary executive theory, on which this full Article 2 removal power hinges, says that we have to put the full executive power in the executive so the executive is accountable to the people. And then we all look at the Federal Reserve and go, whoa, actually, when it comes to an important decision like setting interest rates, the people are a mob who are swayed by demagogues, and the politicians will immediately game the interest rates for political gain and will get runaway inflation. We'd better lodge this with dispassionate experts. At least that's the subtext to the fact that the administration has very deliberately not challenged the removal protections for Federal Reserve Board members. So this case involves board member Cook. It raises the age-old question, can you be fired for cause by Truth Social Post? I slightly joke, there is a letter in there somewhere, but what happened was President Trump said that Cook needs to resign because she signed 2 mortgage applications in which each she said that the home would be her primary residence. The administration claims that this is amounts to a fraud that brings into question her ability to serve on the board. In the lower courts, muddying matters further, I would argue the lower courts ruled in Cook's favor on the grounds that she is weakest on. We have the notion that you can't be fired for cause for things that you did before you took office. And you have the notion that a government official on the Federal Reserve has a property interest in her position. I think those are actually the weakest grounds for Cook. And then you further have the problem that the statute at issue here doesn't have an inefficiency, malfeasance, or neglect language in it. It just says for cause. And so a textualist might say that because these things are not fleshed out, the president should have broad discretion. Having said all that, I don't think the justices had any appetite for allowing this removal to occur. I should note this is in a preliminary posture. The administration has sought an emergency stay, in effect, of the lower court ruling so that it can remove Cook while the litigation moves forward. There is this intense feeling on the court that the Federal Reserve is special. Again, if you were truly for the unitary executive, you would say that the Federal Reserve has much more power than the United States Bank, the analog from history that is waved around to claim that the Federal Reserve is special. But that doesn't look like what the justices want to do. They want to say this is a weird animal. It is separate from all the executive agencies, going back to its history in the banks of the United States. And then the question becomes, didn't Cook need some kind of hearing to establish the cause? It seemed like President Trump prejudged the firing, which seems problematic if you are going to have a true for-cause standard. If that's the standard, then the for-cause provision is empty. Justice Kavanaugh, in particular, brought up the point that if the standard is this weak, every administration is going to fire the officials it wants to fire by digging up old allegations or allegations on flimsy evidence. And we will get a tit for tat that is likely to escalate as time goes on. Justice Kavanaugh, this probably did not pop into his head at random, given his experience. So I think that that's a strong impulse that he is going to act on. The other justices seem to have an appetite to just get this off their docket. They seem to not want to be thinking about this particular issue at this particular time. Justice Barrett noted, I am not an economist. I don't want to be having to grapple with the consequences of market panic if we uphold this firing. So a much muddier case than Slaughter. Paul Clement at one point noted, because of the interim docket nature of this case, the court could just dismiss it in a one-sentence order. He said at this point it would be kind of a weird thing to do that, but I would expect some kind of duck from the court, get this off their docket. And the key distinction you can see in these two cases, the administration challenges whether courts can do much to remedy these firings. The remedy question came up not at all in Slaughter, or barely at all, which suggests that the court doesn't think it's going to need to get to it because the president just has the power to fire. And yet the remedy question came up a lot in Cook, suggesting that the court is going to do something to protect her.
So another pending case that was argued on December 1st pits Cox Communications against Sony Music on a really important question of contributory copyright infringement. Corbin, real briefly, do you think this is going to be the blockbuster that, at least on its face, it can be?
I will be shorter on this because it is not nearly as important to our republic as the removal issue, and because I don't think it will be a blockbuster case. The question here deals with aiding and abetting liability or secondary liability under the Copyright Act. Sony and other copyright holders send notices to internet service providers saying, hey, this copyright infringing work is being, or this copyrighted work is being downloaded in a way that infringes our copyright by individual ISP users. Do something about it. And Cox and other ISPs don't move fast enough for the liking of Sony and the copyright holders. And so Sony won a massive judgment in the Fourth Circuit. It was upheld by the Fourth Circuit, I should say, to the tune of over $1 billion on the ground that in the end, Cox failed to terminate internet accounts. And the overwhelming instinct among the justices was in favor of internet access. At the end of the day, you have a terrible problem with this, that you're in effect, you're going too far down the stack in trying to deal with copyright infringement at the level of internet access. A lot of these ISP accounts are not actually for individuals. They are for entire hospitals or entire universities or regional ISPs. So if you cut off access, you're cutting off access to a huge number of innocent users. Paul Clement, who pops up everywhere here, the Forrest Gump of Supreme Court advocates, he was there on behalf of Sony, and he said, well, universities could maybe just lower bandwidth so that people can't use BitTorrent to download copyrighted works. I would humbly suggest that just is not literate in how the internet works or what universities are using the internet for. So I think Cox is going to win this. There are several precedents that the court can rely on to the effect that aiding and abetting, which is originally actually a criminal law concept, it really takes more than providing a product to the market in a neutral fashion in which you have indifference to what people do with your product or service. You need to do some kind of affirmative act to aid the infringement or the law breaking, which Cox did not do here. It's not like it had a hotline where it said, here, contact us, we'll help you infringe. They're just providing internet access indifferently to all users. And I think that is going to be a dispositive fact here. I think Cox is set to win this one.
Thanks, Corbin. So we'll get to the cases that the court's going to look at over the next 3 months. Interpretation and application of the Federal Arbitration Act seems to be an evergreen issue for this court, Roberts Court. The company that brings us Tasty Cakes and Dave's Killer Bread convinced the court to hear its appeal on the FAA's application to delivery drivers. Yaira, what will the court consider in Flower Foods versus Brock?
Yes, so as you say, there have been many Federal Arbitration Act cases. The court is always very interested in this subject. And this case really is a continuation of a number of recent cases that have really focused on the transportation workers exemption under the statute. The FAA provides an exception for contracts of employment of seamen, railroad employees, or any other class of workers engaged in foreign or interstate commerce. In 2001, so going back quite some time, the court construed the exception, the clause at the end for class of workers engaged in foreign or interstate commerce, to focus in particular on contracts of employment of transportation workers. And the question is, well, who counts as a transportation worker and how do you figure that out? And the court has visited this question several times. In Southwest Airline, the court held that airline ramp supervisors who unload and load interstate cargo are exempt because they play a direct and necessary role in the free flow of goods across borders. And that precedent is very important here because what's going on in the facts of this particular case, Flowers Foods, is you have these drivers who will deliver goods inside a state. And here it's baked goods, as you say, maybe it's tasty cakes, I'm not sure exactly, but some sort of baked goods, and they're being delivered within the state. And there are, of course, local drivers who do things like that, right? There might be a bakery on your corner, then there's a truck that delivers it to your house, and that's, very local. But here, the allegations that are relevant in the case are that the worker is not just delivering goods that are made locally and served locally and distributed locally, but rather that the worker, the driver, is a last mile driver. And he is the last step in a chain of connecting goods that are traveling in interstate commerce. And so the real dispute here between petitioner and respondent is when you look at whether someone is a transportation worker, do you look at what they're doing, right? Do you just look at this last mile driver is the same as a local bakery driver? Or do you look at the character of the goods that they're transporting, and are they a critical piece of what's going on in the interstate goods flow and the interstate and the flow of goods across commerce? And I actually think this case is quite close. I think there's always a little bit maybe of a stereotype that whenever you're in the FAA context, the court's going to be more pro-arbitration than not. I tend to think that's a little bit of an oversimplification of things. In particular, I think I would say the better reading of the court's jurisprudence over the past few years is textual fidelity, and thinking, what does the FAA actually require, and whether you agree with them or not on what they hold. I think that is what they are trying to do. And I think they're going to be really trying here to interpret, what does this clause mean in light of our prior cases? And how does it apply to these last mile drivers who are engaging with interstate goods, but they themselves are quite local in what they're doing?
Thank you. On April 21st, the court's going to hear arguments in two consolidated cases, one involving AT&T, one involving Verizon, both involving the Federal Communications Commission, that are an outgrowth of its 2024 SEC versus Jarkessi decision. Corbin, can you give us an overview of this case and what to watch for in oral argument?
Sure. Jarkessi, as a refresher, is a Seventh Amendment case the justices had to grapple with. If you're in an administrative context, when has Congress potentially gone too far in forcing you as a defendant into that Article I court type of hearing? When do you, in fact, have a Seventh Amendment right to take your claim in front of a jury? And the core in Jarkessi is, with the exception of public rights issues, which are incredibly confusing and muddled, generally speaking, if you are being accused of a claim that involves a remedy or a cause of action that sounded in law, then you have a right to a jury trial in the civil context. Here, the Federal Communications Act, the Federal Communications Commission is able to take telecom companies into an administrative process that isn't even really an Article I court. It's more the FCC gets to accuse you of having done something wrong. You, the telecom company, have a chance to submit some written materials in your defense, and that's it. And then the FCC can decide that you have violated the law and impose penalties on you. And this is one of those classic ones where the FCC has discretion to decide what a violation is, and the damages accrue per violation. So the FCC is able to game the number of violations and impose ginormous fines if it so chooses. From there, the telecom company can either pay up and then appeal to a federal court of appeals under the Hobbs Act and have its appeal heard under the Administrative Procedure Act, or it can just sit on its hands and wait for the FCC to refer the matter to the Department of Justice for collection. At that point, the DOJ can bring a case in court, and then you would get your jury trial. And then the question becomes, does this violate the Seventh Amendment as interpreted under Jarkessi? We have a circuit split where the Second Circuit says this is okay, and the Fifth Circuit says it is not. The basic issue here, the Second Circuit said, well, even though there's a delay, ultimately, if you sit on your hands, you do end up getting a jury trial and that is good enough. There are several problems with this. First of all, the actual proceeding before the FCC itself looks like something that should be trigger a jury trial right. So that's one problem. And then secondly, does this delay, does it actually satisfy the Seventh Amendment? So telecom companies are repeat players with the FCC. They suffer harms by virtue of being delinquent on paying civil penalties, including the FCC being able to reject applications for stuff down the line because they say you're basically a scofflaw and we're going to take that into account in approving your license application or whatever. Not surprisingly, the parties claim that this has never occurred, that a telecom company, as far as they can tell, has never actually waited and tried to go the jury trial route. Clearly should be a trial. Civil penalties, this is something that sounded in law. You couldn't get civil penalties at equity. So it's all about, can you delay and then do the trial and resolve the Seventh Amendment issue that way? I think a majority of the justices are going to be very skeptical of this notion that the period of limitation here is 5 years. So the FCC could potentially let this hang for quite a long time while the telecom company is just hanging on to see if it will ever get it. It's not in the telecom company's discretion. It's in the Department of Justice, well, the FCC and the Department of Justice's discretion whether this lawsuit gets brought. So in this case, it's all about location, history. Telecom companies collect data, obviously cell site location information. We'll get to that in another case on our docket here. The telecoms let various third parties access that location information, or at least they did at the time this case arose. Some companies allegedly misuse that data. The telecom companies are being blamed for this. They ended up suffering a large penalty at the FCC. That's what led to these challenges up in the courts of appeals. So that's what the case is specifically about. At any rate, I would expect that this will be a modest extension of Jarkessi, and the telecom companies will get their day in front of a jury.
A critical area for interstate commerce in America is federal preemption. The court will hear arguments in 2 cases that involve a clash between federal law and state common law legal claims. First, Montgomery versus Caribe Transport, to be argued on March 4th, involves selection of motor carrier or driver and attracted an impressive array of amici, including notable legal academics, 30 states, Honda, Amazon, and WLF filed one as well. Yaira, why is there such an interest in what really could fairly be termed a rather boring case?
Oh, there are no boring cases, and this one is no exception to that rule. You never know what the court's going to say, particularly in some of these hot topics that keep coming back, like preemption, which really is the focus of a lot of litigation going on across the country right now in terms of business interests. And I think we're getting 2 really nice, hopefully, decisions from the court that might shed light and clarity on this area for the lower courts. So in Montgomery, the specific statute at issue is the FAAA, not to be confused with the FAA, the Federal Aviation Administration Authorization Act. And the basic issue is that this was part of an economic deregulatory effort by Congress in the 70s through the 90s. And as part of deregulating at the federal level, Congress wanted to make sure that states didn't fill that new gap that existed as they deregulated at the federal level. And so the statute itself, the FAAA, preempts state laws that are related to a price, route, or service of a motor carrier or broker with respect to the transportation of property, which is a very broad preemption provision. And then there is also a savings clause or a safety exception, which says that the FAA preserves or accepts from preemption the safety regulatory authority of a state with respect to motor vehicles. And the real question in this case is, what does that save? What does that keep? And the facts that here are just whether the FAA preempts state law negligent hiring and selection claims against freight brokers, the people who select and hire particular motor carriers and drivers. And they're licensed under federal law. And the question is whether you can still bring a negligent, a state law negligent hiring selection claim against them. So as you were alluding to, I would say it sounds pretty dry as a legal issue. But the reason there are so many amici here is, of course, one question here is, well, how do you interpret these particular statutory texts? And that question is of some relevance more broadly because there are safety clauses in lots of statutes, and that will have implications for other statutes. But the more conceptually interesting questions are, one, when you look at the sort of preemption clause that we have in the FAA and you understand it in light of what Congress was attempting to accomplish here, how do you construe that when you look at state law negligence, right? So how far does that preemptive intent as manifested in an express preemption provision reach into state common law negligence? So that's one. And then two is this broader issue where almost nearly all preemption provisions will come with some sort of savings clause. And you can call it a savings clause, you can call it a safety exemption, you can call it something else. And the way in which those two things interact is itself a very hard question, right? You can always read it as the narrowest way possible in terms of the exemption, or you can read it much more broadly. And courts really disagree on this as a matter of statutory construction about how to come out in interpreting savings clauses. And I think this case, it's, there will be textual analysis for sure, but I think it will also likely display a broader understanding of what tools do you use in deciding whether this is one of these safety exemptions or savings clauses that should be read broadly versus one that should be narrowed in a particular way because of the other textual clues we have in the statute. And that question is obviously going to be hugely important to many statutes beyond the FAAA.
The second preemption case, which is scheduled to be argued on the 27th of April, has a really winner-take-all feel. After passing up our opportunities to answer the question presented in Monsanto versus Darnell numerous times in the past decade, the court granted this case from Missouri. Two questions for you on this one, Yaira. First of all, what's at stake in this case?
So I just want to fully disclose that I was in the office of the Solicitor General during the prior round of this case. You'll see my name on the brief. The federal government is participating here. The federal government, the various petitioners mostly have asked the court to take up this issue before. This is, I think, the third one that I know about in which the government participated. On the first one, the government sided with Monsanto. On the second one, the one that I worked on, the government sided against Monsanto. And on this one, the government is back siding with Monsanto. So it's a good illustration of different approaches that the government has taken to an issue over time and how the SG's office deals with that. I think their brief is, always very candid about the position they've taken previously, and then, why they've changed position in a particular case. So what's at issue here is the Federal Insecticide, Fungicide, and Rodenticide Act, which, as relevant here, is a comprehensive regulatory scheme that governs the use, sale, and critically, the labeling of pesticides. And for decades, the EPA has exercised authority under FIFRA to find that Monsanto's Roundup line and its active ingredient, glyphosate, do not cause cancer in humans, and repeatedly approved Roundup's label without any sort of cancer warning. The question is whether the scheme itself and the approval of Roundup's label, which does need to be approved, preempts claims brought by plaintiffs across the country that seek to hold Monsanto liable for not warning users that glyphosate causes cancer. And this is a pretty, I think, huge issue because often you'll have federal schemes that are either very comprehensive or require certain things. As here, Monsanto can't change its label without talking to the EPA. That's how Monsanto portrays it. And the question is, well, then can you still be held liable under state tort law for a failure to add a certain labeling, a failure to add a certain warning to your label? The circuits are split on this question. It's a very difficult one. And I think it's hugely important to thinking about the scope of federal preemption because how it applies and how deeply it reaches in to negligence and to these sort of common law actions that we've historically allowed plaintiffs to bring.
Second question is, how closely do you feel the court's going to be divided on this particular issue?
You never want to be wrong about these sorts of predictions, but I would predict closely divided. I think the best indication of that is that we've had three changes in position on this issue, this exact same issue from the Solicitor General's office over the past 10 years or so. And I think an issue that the Solicitor General's office finds very hard is likely to be an issue that the justices likely find complex and hard and worthy of different opinions. But I also think that probably is a good thing in this area. I think the push and pull between the majority and the dissent on this will likely get to a better outcome and a more nuanced outcome. So I'm hopeful that we get some clarity about the interaction between these sorts of provisions and these sorts of schemes and state law tort claims.
Thanks. The other case the court's going to hear arguments on April 27th is Chattery versus United States, which involves the execution of a geofence warrant. First of all, Corbin, what's a geofence warrant, and why should our viewers be paying attention to this case?
Well, as its name suggests, a geofence warrant places a boundary around a certain geographic area and then asks which smartphones pinged a cell site or gave other location information within that boundary during a specified amount of time. And it is very important as it taps into larger questions about the interaction of the Fourth Amendment and technology, which is a deeply interesting philosophical issue. The Fourth Amendment is an 18th century provision, like them all, but you really feel it here because it protects persons, articles, places, and effects. Persons, houses, places, and effects of a person. What the founders had in mind was somebody busting down your door and going through your papers in your desk. And it held pretty closely to this conception of the Fourth Amendment as applying to physical stuff, all the way through the Olmsted decision in the early 20th century, in which it said that wiretapping a line going outside of your home for a telephone or a telegraph is not a Fourth Amendment search, because after all, it's outside of your house. It's not one of your property interests. It's out there in the world. It backed off of this in the Katz decision in the 60s, created a more general privacy standard for the Fourth Amendment. And yet it continued to be arguably behind technology in its third-party decisions later in the 20th century, in which it said, well, if you give information to a third party, you've relinquished that privacy interest, say in your bank records or in the phone numbers that you dial with the telephone company. And we now see the problems that raises in a modern world where your phone, which, that's your effect, but it's sending signals out to cell phone towers all of the time. A lot of us edit documents in the cloud. And so our papers are no longer in our desks in our home. They're held by a company out there. So it's pretty counterintuitive to say that we've relinquished all privacy interests there. The court has generally tried to stay out of these issues as much as it can. We've gotten some key rulings, the main one of which is the Carpenter decision, which says that you do have a privacy interest in your cell site location information when your cell phone pings a tower, at least for historical records where you were over a period of time. That's just too invasive. So we're going to ignore the third party doctrine there. But Carpenter left open all kinds of questions. What about your real-time location? What about other location history information? So everything is left to play for in this case. But that background is important because within the specifics of this case is a much larger, difficult, fraught philosophical debate about how the Fourth Amendment is to be brought into the 21st century. If you want me to
expect
now,
that? I'm sorry. Go ahead.
If you want me to now get into the specific case,
okay. No, fine. Go ahead.
Yes. So, Chattery. I don't know if I still have to say allegedly. Adam Unikowski, able counsel for Chattery, says someone robbed a bank. But in this case, a geofence warrant helped the government narrow things down to Mr. Chattery. And based on my read of it, it looks like this is really key evidence. This is actually one of those classic cases where you see the tension in the Fourth Amendment of if you toss the evidence that led to the wrongdoer, do you let the wrongdoer go free? So that's, the interest in crime prevention and punishment on the one hand versus what looks a lot like dragnet surveillance. And the ability to use technology to really get a complete picture of a person's movements. As Unikowski notes, can we do geofences around political protests or around a church? So there are really heavy interests on both sides here. The question is going to be, does the court want to extend Carpenter to geofence warrants? And you can definitely see the logical progression that gets you there. If your cell site location information for an individual is too invasive, then why shouldn't a geofence warrant also be too invasive? You have sort of the high level principle that we get from Justice Jackson that the purpose of the Fourth Amendment is to ensure that the government does not have an all too pervasive ability to surveil the citizenry. The purpose of the Fourth Amendment is to put some sand in the gears and make sure that the government cannot watch you at all times. On the other hand, the other way it could go, a geofence warrant, you could make the case looks like just crime scene investigation. It is focused on the place where the crime occurred. It is the digital equivalent of putting the yellow tape around the area, cordoning it off, and then seeking evidence in that area. And if you look at it that way, then maybe this is distinct from Carpenter. The government is not trying to track individuals, create some kind of picture of their private life, following their movements the way that you could do with historical cell site location information. And if you look at it that way, then you may be sympathetic with some of the judges below who found that this is not a search to begin with. In the Fourth Circuit, we saw an incredibly divided court. An en banc Fourth Circuit affirmed, I believe it was equally divided in a one sentence per curiam opinion, but then they proceeded to have something like 8 or 9 separate opinions. You have a situation where the Fifth Circuit has gone a different way from the Texas Criminal Court of Appeals. So in Texas, it matters whether you're being prosecuted by the state or the federal government as to whether this is a search. And that ties me back to where I began, that all of this confusion is because we're on uncharted territory trying to figure out how we make connections or analogies to modern technology in a way that is coherent, tying it back to the Fourth Amendment as originally understood.
So at the search stage, there were surprisingly not a whole lot of amicus briefs. There was one interesting one by X. Do you expect that there'll be more amicus briefs now that we're at the merit stage from tech businesses?
That's interesting. I have to wonder if people gave up. The Supreme Court after Carpenter, which was, I think, 6 years ago, maybe more, denied petition after petition after petition on a lot of key Fourth Amendment issues around this topic I'm discussing. It's not just geofence warrants, it's reverse keyword searches on search engines. It's poll cameras where, the police no longer have to send a guy out and do a stakeout in front of your house. They can just put a camera on a telephone pole and watch you 24/7. It's ISP records. There's just all kinds of questions that are open with the Fourth Amendment right now in terms of how it deals with new technologies. We're going to have issues about the government purchasing data, and is there a Fourth Amendment valence there? So you had a lot of petitions on a lot of different issues that I was watching many a time that I thought, oh, this is the one they're going to grant. And the court denied. They seemed really hesitant to dive into these issues. So maybe people just threw up their hands and decided, well, the court will get around to it when they get around to it. Now that they have, yes, I would expect a flood of amicus briefs in this case because it's going to be hugely important, not only for this specific issue, but in setting standards and putting language in decisions that's going to affect all of those other issues I mentioned and more.
Thanks, Corbin. Just to remind our viewers, if you have any questions, please use the Q&A function in the chat. Actually, we do have a question. from Sherman. In the Roundup case, can Yaira, address whether the proposed settlement was recently announced, could either moot the case or lessen the practical effects?
On mooting the case, the Supreme Court typically holds on to cases once it's granted cert. So I don't think we know yet what will happen. It's not impossible, but I think they tend to, once they put in the time and effort to review it for cert, try to hold on to it. On the practical effects, of course, for Monsanto, maybe, but I think this case has wider significance, as we talked about earlier. I think there's a huge question here about how to think about these comprehensive federal schemes that require affirmative labeling requirements or warnings or things like that on products. And I think that if the court does hold on to the case, there's no way that this decision won't have tremendous practical implications, both for Monsanto, but also for companies across industries.
Thanks. Would either of you like to talk about any other pending cases that we've not touched on? We'll start with Corbin first.
First, I have to finally get it right on the spot. Persons, houses, papers, and effects. It's funny what your brain will do when you're in front of an audience. Okay. The case I would bring up is Sripech versus Securities and Exchange Commission. Very, very interesting issue for legal nerds. Kind of the mirror image of the Jarkessi trial right in Questions at Law. Here we're dealing with questions of equity. The Sarbanes-Oxley Act put into the SEC Act the ability of the SEC to get equitable relief. And what does that mean? Sripech, I believe, sold penny stocks in a pump and dump scheme. And what he alleges is, I may have profited from this, but there is no harm done to individual investors who relied on me. So there is no money belonging to victims. And that means that this is quintessentially not equitable. You're trying to penalize me, which, if we recall back to our Communications Act case, is a legal question. I want to take us on a very quick journey back to Mertens versus Hewitt Associates, one of those Supreme Court cases that doesn't seem like it matters much at the time and ends up having an earthquake effect going down the years. ERISA, 1974 law, has a similar equitable relief clause. And Justice Antonin Scalia, in a good demonstration of how maybe at times he was so brilliant, he was a little too brilliant for his own good. He says, well, equitable, obviously that means that we need to be looking back to the divided bench and only giving remedies that were available in the Court of Chancery in ye olde England in the 19th century. That's what this means. And Justice White, in a dissent, said, I think in 1974, maybe Congress just meant fashion a remedy that is fair given the circumstances. And that, as something we've seen in dissents down the years, Justice Ginsburg, Justice Stevens have made that point. But Mertens stuck. And ever since then, in statutes that have the word equitable, the Supreme Court has tortured itself trying to remember how these equitable remedies work. They're actually incredibly complicated. They get into issues of, can there be joint and several liability? Are there tracing requirements on the property? All kinds of weird bells and whistles to equity jurisprudence, and yet the Supreme Court has been stuck with this. So this bled over into the Securities Act statute, where we're now doing the same thing, what was available at equity. And the Supreme Court has kept the Mertens approach, but clearly doing it to the full was just too much. So in a case called Liu versus SEC, Justice Sotomayor says, well, disgorgement is enough. Justice Thomas, in dissent, says, disgorgement was not a thing at equity. And the main thing that you get by using this disgorgement concept from the 20th century, it eliminates the tracing requirement. So the crazy thing about equity was, if I steal your horse and the horse dies, the tracing requirement says that you are owed the carcass back, not the money value of the horse. Good example of the weird results you get with equity. Liu says, okay, we're just going to do disgorgement, but it leaves all these other equitable questions open, one of which is, is it equitable relief if the money is going to the government and not to victims? And this case sets up that question. So seems like a very mundane securities case, but actually it gets into a lot of fascinating questions about the history of law.
Thanks, Corbin. Yaira, anything else that you wanted to mention in terms of cases in the second half here?
Sure. I was going to mention ExxonMobil, which my colleague Morgan Ratner is arguing, I think, in a week and a half or so, which I think is a really fun case for those people who've been following the concept of waivers of sovereign immunity and more broadly in the court's jurisprudence, clear statement rules. This case is really about, and I won't get into too much detail, but about a particular statute, which is Congress passed to deal with Cuban confiscation of property in the 60s. And that in that statute, it provides a cause of action against including government entities and whether that is a clear enough statement to abrogate sovereign immunity as to government instrumentalities, or Congress also needed to, or you also need to satisfy an exception within the Foreign Sovereign Immunities Act. And the case is just really fun for people who are thinking about the magic words requirement and the clear statement rule, because I mean, essentially, in some ways, it seems that respondents are arguing for a super special clear statement rule or a very, very clear statement rule when you're in the Foreign Sovereign Immunities Act context. And you have to wonder how many versions of a clear statement rule one can have. I think we're going to see a lot of talk at the court about this when it's heard in a couple of weeks. So it's a really interesting case. The background, sort of the Cuban confiscation of property is very, very interesting. And then the statutory question actually has broader valence beyond this particular, the Helms-Burton Act, which probably doesn't come up too much in everyone's practice.
Right. Thanks. Another question we have, I'm not sure if either of you would be able to answer this, but any thoughts on United States versus Hamani?
I'm familiar, so I'm happy to talk about it if helpful. So this case is, a really interesting one. Obviously, the court has been issuing numerous pro-Second Amendment cases the past few years, but this case is about whether the restriction on firearm possession by a habitual illegal drug user violates the Second Amendment. And so it really hits, in some ways, these strong Second Amendment concerns and considerations about that with, what we think of as core issues in criminal law, right? Which is, making sure that people who we don't trust with firearms don't have firearms. And it's interesting because there's a lot of analogies in the Second Amendment context. The court has been looking very deeply at founding era history, and there are founding era laws that are restricting the rights of drunkards, for example. So there's an analogy, and you always have a question of how close the analogy is and how well it fits. But the government was the one who sought certiorari here after the Fifth Circuit invalidated this restriction on firearm possession. And again, you never want to predict which ways these are going to come out, but I think the government has a very strong argument here defending this restriction.
So real quickly, are either of you following any cert petitions that the court is likely to grant during its time during this term, but to be argued in the next term?
There's always a lot of interesting ones, so I'll quickly highlight Epic versus Google, which could potentially bring the antitrust refusal to deal standard back to the court. There is potentially a return of the Vulo case. Supreme Court heard that a couple terms ago about government jawboning. Does it violate the First Amendment for the government to try and suppress speech through ways that are not maybe direct censorship, but by yelling at private parties in one way or another? And then one I just saw that looked interesting is begging protected by the First Amendment coming out of the 11th Circuit.
And I'll just add one more that I think is really interesting coming from my DC Circuit roots, but it's the Department of the Air Force versus Guahan, which will explore the question of what is final agency action under the APA. And this is a question that comes up all the time. And I think courts are all over the map on this question. And I think it's fascinating. The government is seeking cert again. And I think it's going to be really, really interesting if this case is granted.
Well, we have come to our 1 o'clock hour and got through everything that we wanted to get through. So we really appreciate having you both with us today. Thank you to everybody who joined us online and for the questions that you asked as well. If you have a few moments after we turn off, there's a real quick survey, if you could do that real quick. Thank you to Corbin and Yaira for joining us today and taking the time to prepare. Everything was fantastic. Thank you.
Thank you.